Thanks, Carrie. Hi, everyone. It's my pleasure to introduce today's speaker. To many, he needs no introduction. Jeff Tannenbaum is one of the nation's leading nonprofit attorneys and is also an accomplished author, lecturer, and commentator on nonprofit legal matters. As managing partner of the nationally recognized Washington, D.C. Tannenbaum Law Group, a four-attorney boutique law firm focused exclusively on the legal needs of nonprofits, Jeff counsels his clients on the broad array of legal issues affecting trade and professional associations, charities, and other nonprofits. For 19 years, Jeff practiced law at the Venable Law Firm and chaired its nonprofit practice for most of that time. Among numerous other honors and awards, Jeff was the 2006 recipient of the American Bar Association's Outstanding Nonprofit Lawyer of the Year Award, and is one of only 5 lawyers in the prestigious U.S. Legal 500's Not-for-Profit Hall of Fame, and has been ranked as a best lawyer for nonprofits and charities law by U.S. News and World Report every year since 2012. Jeff is the author of the ASAE published book, Association Tax Compliance Guide, as well as the award-winning book, Quarantine Cocktails, and currently serves as chair of the American Bar Association's Trade and Professional Association Subcommittee and on the ASAE Legal Advisory Council and Public Policy Committee. Welcome, Jeff.
Thank you. Thanks for having me today.
Wonderful. Thanks, Lisa. Thank you, Jeff. The questions are already coming in, so let's get going. We're going to jump right into it. The first one, is it a good practice to have all staff sign a conflict of interest form? This questioner is thinking specifically of potential vendor selection issues where someone may have a spouse employed or financial interest in that potential vendor.
Great question. Short answer is yes, absolutely. It's most definitely a best practice, and you should absolutely have a conflict of interest policy that applies to your staff, as well as to your officers, directors, committee members, and sometimes other volunteers as well. And it's important that that policy be accompanied by a disclosure form that should be circulated every year to all of those volunteer leaders, as well as to staff. Conflicts of interest arise at the staff level, as well as at the volunteer officer, director, committee member level. There tend to be different types of conflicts at the staff level or at the volunteer level, but really in the end, it's the same body of law. It's all the same. As I've always said, a nonprofit organization can't do anything about a conflict if it's not aware of it. So that, that was a perfect example of a staff member who has, a friend or family member or a business associate, that runs some company that wants to provide services to the nonprofit organization. In a situation like that, not, as I've also said many times, not all conflicts of interest are bad for the organization. The key is, how does the organization manage the conflict? So for instance, there's generally 3 hallmarks of good conflict management. One is disclosure. We have to know about it. And that, by the way, that annual disclosure form should become a regular practice, but it also should require that all of these individuals have an obligation to disclose conflicts as they arise during the course of the year. So it starts with disclosure, and then it involves recusal, which means the person that has the conflict removes themselves from the decision-making process. And then thirdly, you have a group of independent decision makers. At the staff level, it could be the CEO or executive director, could be a senior staff team, however you want, as long as the person that has the conflict is removed from the decision making. So those individuals, whether it's CEO at the staff level, whether it's the executive committee or an audit committee or the full board at the volunteer level, they look at the situation and they say, okay, what is in the best interest of the organization? So for that example that you gave, if that staff member has some business, colleague or family member that has some great consulting firm that wants to offer services to the nonprofit organization. It might be that they're really good at what they do, and they're willing to offer their services at half of the going kind of fair market rate for those services. And so that's not necessarily a bad thing for the organization, but you need to have a group of disinterested decision makers look at that, look at the options. Maybe there was an RFP done, look at all the proposals and see, okay, what is in the best interest of the organization? And as long as that group of disinterested decision makers makes that decision with that person that has the conflict removed, that's the proper way to deal with conflicts. And then also with things like, renewal of any contract with a vendor or something like that, the person with the conflict also should be recused from that decision-making process.
Excellent, thank you. Yeah, I think it's a really good point about as conflicts arise throughout the year too, because I'd be surprised if a lot of organizations are not noticing that and just working with the annual disclosures. Okay, next question. Is there a ceiling for an amount of net assets to jeopardize the 501c3 status?
I always get that question every once in a while. I've been practicing law for 26 years and doing presentations like this for that long, and always seem to get that question at least once or twice a year. The short answer is, from an IRS perspective, which is really the primary lens you'd be looking through, whether you're a 501c3, C4, C6 organization, whatever you might be. Short answer is really no. There's no IRS limit on how much net assets you can have. I think it's kind of a myth that there's some people believe that there's some limit on how much you can maintain. That being said, this issue has come up most recently with some large kind of wealthy tax exempt colleges and universities. It's come up with some of the Ivy League schools that have massive endowments, and particularly some members of Congress on Capitol Hill questioning, how do you keep raising tuition when you have all these massive endowments? And there have been some proposals circulated on Capitol Hill to require a certain amount of spend down, particularly by college and universities that have certain level of large endowments each year. But generally speaking, as long as you have some legitimate stated purpose for those reserves, for a rainy day fund, maybe you're saving to buy a building, maybe you're saving to invest, or purchase another. I don't know, if you're, say, an association and there's this for-profit trade show in your industry, and you're thinking you might want to purchase it from the for-profit company that owns the trade show down the road, and you want to save for it, whatever it is, it's just not a bad idea to have some kind of board resolution or investment committee resolution that just says, here's a reason why we have such a large endowment. The endowment's not that large, and I think one rule of thumb I've heard a lot from CPAs in the space and investment advisors is that you should have reserves that are ideally equal to 1 year's operating budget for the organization. But if you have reserves that are 3 or 4 times your operating budget, that's not necessarily a problem. So long as you have some legitimate tax exempt reason or reasons for accumulating that reserve, it's really not an issue. And as you all know, earnings from reserves, interest, annuities, dividends, capital gains are all exempt from unrelated business income tax. So they're considered passive income, and they're not subject to tax.
Great, thank you. That must be the first poll. There's a little chime. There was a follow-up question on the conflict of interest real quick. What about their contractors? If they're using all contractors, should they all be signing a conflict of interest as well, service providers?
That's a good question. I don't get that one very often. That's not a common practice, I will say that. But what is a common practice is to put a provision, and we have one in our model independent, nonprofit independent contractor agreements, where the contractor is obligated under the contract to disclose any conflicts of interest that they have. Mm-hmm. So it's not really the policy and the form wouldn't typically be applicable to contractors, but you should always have written agreements with your independent contractors for a whole array of reasons, which I could have done entire hour-long sessions on that alone, and all the different provisions that should be in there, from IP to independent contractor versus employee status to deliverables, the ability to terminate with or without cause, what happens upon termination, all payment of fees, all those different things. But one of the things that you should put in there, things like conflict of interest disclosure, sometimes provisions regarding non-solicitation of employees, confidentiality and non-disclosure, and other things like that.
Great, thank you. All right, there's a couple of questions about credit card fees, so I'm going to try to take them in turn. First, can you speak to charging credit card fees back to customers? This is a for-profit sub of a large not-for-profit in the district.
Yeah, I saw that question pop up. First off, it's very common for nonprofits, even those just taking straight up donations, to sometimes charge or deduct from that contribution the credit card fees. I'm not aware of any legal reason why you can't do that. It's really a question of disclosure. And that becomes really important, especially when you're talking about donations and contributions and fundraising, because sometimes, like the state attorneys general that are the primary regulators in this area, if you're not disclosing that you're going to deduct a credit card fee, they can determine that to be like a false or deceptive marketing practice. So whether it's straight up donations, whether it's a commercial co-venture, whatever the case might be, if you are going to deduct the credit card fees, and you absolutely should make that very clear to the donor or payer before they pay. But it's really just a business decision.
Thanks. And then kind of related, is there a legal limit for credit card fees or convenience fees, late fees for a nonprofit? There's asking specifically about DC, but also just in any state. Are there legal limits on the amount the fee can be charged?
I can't answer that for sure. That's really not an area that we get into very often. And it would be a state law based issue if there are any limits. I mean, what I generally recommend is just to only charge what your actual fee is, what your actual costs. If you're talking about late fees, like for late payment of membership dues or late payment of sponsorships or whatever else might be due, I mean, that's generally very acceptable. Again, it's really about disclosure. As long as you're sure to be disclosing what those late fees are. If you're disclosing what the fees are, and as long as for like credit card fees and processing fees, you're only charging your actual costs. I can't, it's hard for me to imagine that being an issue. Now, if you were really pushing the envelope and having some exorbitant charge that's well beyond the actual cost, that potentially could run afoul of some state laws, but that's not really something I can speak to.
Gotcha, thank you. Okay, this is the big one. Is it risky to hire new employees fully remote? Do you have a checklist of considerations we should review if we hire someone fully remote that isn't in our state? And I know that's probably a bigger question.
It's a big one. I had an hour-long conversation with a client yesterday about that. The general counsel of a large nonprofit kind of health-related organization based in DC. Prior to the pandemic, I think she told me they had like 3 or 4 remote employees across the country. Now, and they have, I think, 150 or so employees. Now they have requests from tons and tons of employees to just be able to work anywhere they want at any time. So here's, in essence, what I told her, and that I'll tell you guys. First off, it's a big area. I just did one of these kind of Ask the Nonprofit Lawyer sessions last week and probably had 10 back-to-back questions all about this topic area alone. There's a lot of complexity and nuance in this area, but a few high-level kind of things to keep in mind. First off, generally speaking, you don't have to let workers work remotely from anywhere if you don't want to. Now, these days, if you want to attract and retain good talent, it's going to be very difficult not to do that. And I don't need to tell any of you guys that. But there's no obligation to do so. Secondly, there's no obligation, if you are going to allow workers to work remotely, there's no obligation to let them work anywhere in the country or anywhere in the world that they want to. You can put limitations on it. In fact, a number of our clients say you can work remotely in every state except California, or they name certain other states. Some say you cannot work remotely, at least on a long-term basis. It's one thing if you're going, taking a month-long vacation to a warm weather place in the middle of the winter, but we're talking more long-term. Some say you can't work, overseas, with different time zones because it makes it too difficult. And some say we want you to be, as you all know, even in the DC area where I think all of us are, a lot of nonprofits are now kind of moving back to a hybrid schedule where, you're in the office 2 days a week, out of the office 3 days, but limitations and restrictions on which days you can do it. Some say you have to be in the office once a month when your department is having a meeting. Those sorts of things might dictate what states you're allowing people to work from. There also is no obligation to pay for employee travel to come to the office. So if someone decides to move to Denver, Colorado, and you're based in DC, and you're requiring them to be in the office once a month for staff meetings or whatever, you do not have to pay for the cost to get back. But one thing you do have to do, and this is really important for everything I just said, is that you have to treat similarly situated employees objectively and consistently. Otherwise, you risk discrimination claims, and you're also going to risk a lot of employee resentment and disgruntled employees if you don't do that. So when I say similarly situated, some employees, like for instance, if your nonprofit puts on a lot of meetings and you have staff who need to, so maybe not talking in the office, but they have to be physically in person at meetings, and they say, I just want to work remotely full time. That's not consistent with the job description. You don't have to do that. Whereas if you have other employees whose jobs could be done fully remotely, you could allow them to work fully remotely, but you need to treat similarly situated buckets of employees the same and do it on an objective basis, on a consistent basis. You should be clear as to what your policies are. You should have a very clear written remote work policy, usually as part of your employee handbook. You should also obligate employees to let you know when they move from one state to another, put an affirmative obligation on them to do that. And then kind of the other big thing to keep in mind is that where the employee is principally located, I'm not talking about a vacation, but where they're principally located, that makes that employee subject to the employment laws of that state. So you might have never dealt with California's employment laws. Trust me, they're not, even DC, which is a very employee-friendly state, California takes it to a whole nother level. And there's a lot of different rules that apply for employees. There's a lot of different kind of tax and business and other obligations in certain states. And when you have an employee in that state, they're governed by the employment laws of those states. You need to modify your employee handbook accordingly. Sometimes you end up having a lowest common denominator approach because you want to treat everyone the same. You're also subject to, qualifying to do business as a foreign corporation in that state. You are, you generally have to register for tax and business license purposes. You have to register for unemployment and workers' comp and payroll tax and other issues. It's the general counsel I was talking to yesterday. She was saying it's so much damn work and it's so hard to comply with all these things in the state, and it's a huge burden. And by the way, I have not, and she has not, and many other of my clients have not found a single vendor out there. If any of you know of one, please let me know, that kind of would handle all of that. She said, I will gladly pay a vendor to handle all of that for us. I haven't found one yet. And even some vendors that will handle certain parts of it, I've seen, even with my own law firm, but with a lot of clients, I've seen tons and tons of errors and mistakes made. It's a difficult, cumbersome, complex process. So, this idea of, because a lot of workers do want to be able to work from anywhere at will, you don't have an obligation to do that. You can push back, you got to strike the right balance. And I'm not talking so much from a legal perspective, but just from an employee relations and employee retention perspective and being able to track staff. You got to try to find that right balance. It's a really difficult area. I do a lot of counseling of clients in this area. And then finally, the last thing, and this came up a lot during the early parts of COVID, particularly maybe in 2021, when the vaccines really came online and some employers, particularly outside of the DC area, started requiring employees to come back in the office. There is so if you, for instance, were going to require that people be in the office a certain number of days a week or on site at meetings, a certain number of days a week, and someone says, well, I'm allergic to one of the ingredients in the COVID vaccines, and I can't get a vaccine, and therefore I'm immunocompromised, and it's very risky for me to be there. If someone has, for employees, either a qualifying medical condition that makes it risky for them to get a COVID vaccine, or if they have a sincerely held religious belief, this is under Title VII of the Civil Rights Act, that prohibits them from getting the COVID vaccine, you do have to make a reasonable accommodation for that employee, so long as the reasonable accommodation still allows them to perform the essential functions of the job, and so long as the accommodation doesn't pose an undue burden on the employer. So there might be some situations where even if you don't let anyone work remote full time, if they fell into one of those buckets, it's up to the employer to determine what is a reasonable accommodation, not up to the employee. They don't get to demand what they want. But there are some cases where if a position lends itself to full-time remote work, you might use that as the reasonable accommodation. We have seen some organizations do that.
Got you. Thank you. I know that was a lot. So thank you for going through all of that in detail. There was one additional question that was somewhat related about payroll withholding. So if you have an employee in a state where you do not meet the state requirement for unemployment insurance, should you set them up in the state where you are headquartered?
Well, okay, and first off, I don't, this is an area that generally falls outside what the lawyers do, but my understanding is that if an employee is, now permanently residing or long-term residing in another state, most states say that you have to be in the unemployment system in their state. For instance, when we first started our firm, January 2020, and then COVID hit 2.5 months later, our then assistant was previously working full-time in DC, then all of a sudden she was working in Maryland. We realized and found out that we had to register in Maryland for unemployment compensation and insurance, not DC, in order for her to have benefits, because that's where she was principally working. So from the little bit of knowledge I have on this, and I've heard similar things from clients, I don't believe you get to just pick and choose. It goes by, again, where the employee is principally residing.
Gotcha. Thank you.
Or where they're working from, I should say, not where they live, but where they're principally working from.
Okay. So I was noticing when we were getting ready for today's session, I was expecting there to be a lot fewer questions about vaccine mandates and return to office, and this is very welcome to have a change of that conversation. But I do have another COVID related question. Have you heard of any problems with the PPP where a nonprofit has been required to repay the funds? Now I lost my place. Repay the funds for misspending or applying with misinformation. Have you seen other penalties or just repayment?
I mean, frankly, and this has been, you've seen a lot of criticism in the media about, a lot of abuse of the PPP loans, where a lot of loan forgiveness was granted when perhaps it shouldn't have been. I have not seen and heard of a lot of enforcement in the nonprofit sector from that. And I'm not sure how it relates to this issue, because that was really about, during certain periods of time where you keeping, I think it was I did a ton of speaking on this, but it's been a while now. You had to keep like 75% of your staff, on the payroll at comparable levels of, compensation and whatnot for a certain period of time in order to be eligible for forgiveness. But I don't think that had anything to do with where the employees were located.
Yeah. Okay. Thanks. All right. Let's switch gears here. What should nonprofits know about cryptocurrency donation and its relation to AML requirements?
Yeah, so AML is anti-money laundering requirements. That's an area, a very specialized area where our firm has certain outsourced lawyers in some specialized areas that we just don't have the expertise, my 3 colleagues and I, and that's one of them. So I can't speak to AML requirements, but what I can, in terms of cryptocurrency, the area that I've seen this the most, and I haven't done a ton of work in this area at all, but what I've seen is that in terms of, like, if you're a 501c3, and particularly not like a C3 association, but a C3 charity or whatnot, or educational institution or whatnot, it's generally best practice. It is a best practice to have a gift acceptance policy. We work on these all the time. Some are more complex than others. And that's an area where you have a right to say, we will accept gifts in certain forms, like a lot of nonprofits will not accept cryptocurrency donations, and they won't accept cryptocurrency as payment for services, nor do you have to. If someone wants to pay their membership dues or their conference registration fee or their sponsorship with crypto, you don't have to accept that. Again, you should make it very clear up front what you accept, what you don't. Some C3s will not accept donations of property, like automobiles or real estate or land or things like that. Some will for different purposes, like a client of ours, a nature conservancy, regularly accepts contributions of land because they want to, help protect it with easements and for conservation purposes. But a lot of nonprofits don't want to because it's a lot more difficult and cumbersome. It's a lot more difficult to monetize it. It's a hell of a lot more complicated. And so you should just be clear in your gift acceptance policy, what types of contributions you'll accept and what you won't. And then there's certainly a lot of other provisions that go in there as well.
Yeah, thank you. All right, so now some more traditional revenue here. Do you believe 100% virtual conference, trade show sponsorships and exhibitors are UBI, or are most organizations treating them as meeting the exception when they're not?
Yeah, I wrote an article about this, and I don't know if I can't do it right now, but if one of you guys from the staff wants to go onto our website, tenenbaumlegal.com, and look under publications, I think it's on the first page. There's an article about unrelated business income tax and nonprofit organizations that I wrote last year. And it's kind of an overview of UBIT for nonprofits, and then it drills deep into 3 areas: royalties, corporate sponsorships, and virtual trade shows. Well, convention and trade show income, and has a discussion about virtual trade shows. It's an area that's very gray. And the issue is this exception from unrelated business income that's been in the tax code since 1976. And it primarily, applies to C3, 4, 5, and 6 organizations, but it tends to be really focused on the association space. And it was written so long ago, and it was written before the days of virtual trade shows. And then there was some IRS, there was an IRS ruling on this that, again, still quite a while ago, before virtual trade shows could kind of operate the way that they do today. Thanks for posting that. Before they operate the way they do today. And the IRS said basically that the way they interpreted the statute and the exception from UBIT was that a virtual trade show could only be subject to that exception from UBIT if it was held in conjunction with a kind of physical in-person show. But if you drill down deeper into that, there's arguments to be made that even a purely virtual trade show, because of the way that the technology and everything, the way it can operate today, there's still an argument that could be subject to the exception. And the whole idea here, and the reason this exception was ASAE lobbied for it back in the mid-70s, because the IRS was trying to or threatening to tax trade show exhibit fees like advertising, saying, look, it's really no different than advertising, therefore it should be subject to UBIT. And ASAE was successful in getting this exception written into the code. So that's where this is coming from. So again, it's not clear, but if you follow the construct of the exception, and all of this is explained in the article, I think there's an argument that it would not be subject to UBIT. And also, this is a really important point, and it applies with royalties and especially with corporate sponsorships as well. Just because a certain income stream is not subject to an exception from UBIT doesn't necessarily mean it is subject to UBIT. So if something's doesn't fit within one of those boxes, and this happens in the corporate sponsorship area quite a bit, that's a very specific, detailed exception, and it has to do with what kind of benefits you're giving to the sponsor. But even if something doesn't qualify for the UBIT exception, for instance, sponsorships in periodicals are not covered by the corporate sponsorship exception. But if you had just something in your periodical, like a magazine, newsletter, journal, that was just thanking donors, we want to thank this donor, this sponsor for their contribution, and you have a logo of the sponsor, and that's it. Even though it would not be subject to the corporate sponsorship exception because it occurred in a periodical, not on a website or at a golf tournament or something like that, it still, you would then just apply the 3-prong UBIT test. Is it a trade or business that's regularly carried on and not substantially related to your taxes and purposes? And we've concluded in the past that something like that it's not a trade or business, because you're not carrying on that activity with a profit motive. You're just thanking a donor. It's just an acknowledgement of a donation, of a contribution. And therefore, even though it doesn't fit into the exception, you apply the 3-prong UBIT test, it's still not subject to UBIT. So just keep that in mind for anytime you're doing any kind of UBIT analysis.
Excellent, thank you. I do have a follow-up on donation acceptance now. Is a nonprofit required to immediately liquidate stocks and bonds, or is this just best practice?
Is it required to liquidate stocks and bonds
that are received as a donation?
No, not at all. At least I've never heard of anything like that. No, if someone donates stock and the ownership transfers to the name of the nonprofit organization, just like nonprofits, probably almost every one of yours, for those of you that are from nonprofits on the call, on the webinar, you have tons of mutual funds that you own and other stocks and things like that. It's really no different than that. No, but it's really up to what you want to do and how you reflect it in your gift acceptance policy. And a lot of nonprofits, they do want to, whenever they receive any non-cash contributions, they do have a policy of just wanting to liquidate it and turn it into cash, but there's no legal obligation to do so.
Sure. Great, thank you. Okay, now, how would you advise a small charity in addressing the risk of not registering for charitable solicitation in every state they may receive a few donations in that technically could trigger a registration requirement?
Yeah, it's a good question. So there's approximately 40 states in DC that require charities that are soliciting contributions from residents of those states. And again, this is soliciting contributions, not like soliciting members or, soliciting, people to buy publications or attend a conference or things like that, but soliciting contributions, including grants and things like that. Most of these state laws are written very broadly, to suggest if you are intentionally soliciting residents of that state, even a single person, that you're obligated to register under that state's charitable solicitation registration law, and then there's annual reporting that's required. But the practical reality is if you're generally not doing nationwide solicitation, and it's just a one-off here or there, the practical reality is that the state attorney general is not going to come after you, almost certainly, to enforce that. So you got to, just like with a lot of areas of legal compliance, you just got to be practical sometime and weigh the costs and benefits, because it's a pain in the neck and it can be expensive. Most charities that do nationwide solicitations outsource this to one of a number of companies that do this, but it's not cheap. It's a bit of a pain, and unless you're doing it on a consistent basis, I probably wouldn't worry too much about that, with two caveats. There's this set of principles called the Charleston Principles that the state charity regulators and state attorney generals agreed to probably about 20 years ago at a meeting in Charleston, South Carolina, to deal with kind of online solicitations where you are, this is kind of at the advent of online solicitations. And the real question was, if you have like a donate now button on your website, but you're not actively like sending emails or sending, mail or making phone calls to people in a given state, you're not actively soliciting people of a particular state, but you just get occasional contributions from the state. That was one of the main things that those principles were designed to address. They're not law, but the state charity regulators do tend to follow those. And what they basically say is that unless you're receiving regular, kind of consistent contributions from residents of a state, and you're not intentionally targeting and soliciting residents of those states, you probably don't need to qualify. don't need to register. And then one other thing though, if you, for any C3s that engage in commercial co-ventures, you've all seen these, it's like a for-profit company says for the next 2 months, for every, product or service of ours that you purchase, we're going to donate X amount or X percentage to, XYZ charity. There are approximately 26 states that regulate commercial co-ventures, only a couple that require any kind of filing or registration with the state, but they regulate them in lots of other ways, contract provisions that have to be in place, disclosures, other things like that. And one of the prerequisites of a commercial, if you're doing a nationwide commercial co-venture, this is where, and we've dealt with this, I've dealt with enforcement action from state regulators. They're going to look to see, is the charity that that's the partner of the commercial co-venture, are they registered in the states where the CCV is occurring? So that's something to keep in mind.
Good point. Thank you. Okay, we're going to shift gears again. Now we're going to move into working internationally. Okay. So do you recommend any best practices when setting up international affiliates? Considering organizational structure, is it recommended to consolidate and retain control or create totally separate legal entities? Any considerations here in nonprofit law?
This is a big area. We do a lot of work with what are called international NGOs, particularly a lot of like relief and development organizations that work in developing countries, often US based or, US, affiliate of say a UK organization or something like that, where a lot of them in DC are funded by agencies like USAID and the State Department and UN sometimes. And then they have operations in various different foreign countries. We do a lot of work advising them on that and working with local counsel in different countries. And so in most other countries, there are different forms of like registration / local entities that you can create. And there's generally pros and cons and considerations and trade-offs for different things. So for instance, in a lot of countries, it's called a branch office, and you're not actually creating a separate legal entity, but you're registering the US entity as a branch office in that state. In that country. It gives you maximum control, but it has limitations. Sometimes it has more burdens, less burdens, but sometimes, like for instance, if you have donors, like say in a lot of European countries, if you have donors that want to donate to in that country and be able to take their version of a charitable tax deduction, it doesn't work with a branch office. Or in some countries, like in South Africa, if you want to get certain types of government grants, you have to have, like a branch office won't work. You have to set up a separate, essentially South African charity in order to be eligible for those grants. So we work with local counsel to do that for a client of ours. In Europe now, the ECHO, which is kind of their version in the EU of USAID, has new requirements that I think are taking effect this year or next year, I can't remember, that are basically designed to say, if you want to get ECHO funding, you have to have a local charity in the EU, and then they have very specific requirements for who has to be in the board and what kind of control the US entity can and cannot exercise over that. They're basically trying to kind of funnel a lot of their money into truly European entities as opposed to US entities that just open offices over there. So all these things are considerations. Yeah, I'm a big fan of whenever you have, it could be state chapters in the US, it can be foreign affiliates. Having the maximum level of control is very, very important, but then there are trade-offs based on some of the things I just described. But there are ways to thread the needle Like I did one for an international NGO where they want to qualify as a big pot of ECHO funding they want to qualify for. So we came up with a construct to set up an entity over in Europe, kind of a local charity. But looking very carefully at the requirements, drafted an affiliation agreement with that entity that gave the US entity a good amount of control while still adhering to the ECHO requirements. So complicated area, but those are some highlights.
Great, thank you. Sounds very complicated. Okay, so this next question is not about moving to work internationally, but what if they have conferences or workshops in different countries outside the US? Are they going to need to register and file and charge local taxes, value-added tax in these countries?
Sometimes, yes. In fact, a lot of times, yes. And I just had one for a question from a client, a US-based charity foundation that holds kind of in connection with a conference that occurs in Amsterdam every year. They do fundraising there from the attendees of the conference and wanted to know whether they had to comply with kind of the Dutch, essentially their version of charitable solicitation registration before they could solicit donations there. So I reached out to a Dutch nonprofit lawyer that I've worked with before. He and his colleague did an analysis and concluded essentially, no, you are not allowed to solicit. And there's no office there, there's no employees there. But in that particular country, you're not allowed to solicit contributions from residents there, attendees there, unless you qualify with their licensing requirements. So it's very much country specific. But yes, there are a lot of obligations that are going to kick in, even if you don't have employees or an office there.
Yeah. Okay. All right. Now we have a question about the concept of controlled grant in the context of a C3 reporting or not reporting the lobbying expenditure of a recipient C4. What qualifies as controlled grant and what is at stake?
So, like for instance, if a C3 makes call it, this isn't really the term of art, but an uncontrolled grant, just we're going to give you a grant, a general grant to use, in furtherance of our mission and purpose, but no limitations on what it can be used for. And if it makes a grant to a non-C3 organization that engages in lobbying, then there's going to be a presumption that some of the lobbying expenses incurred by say the C4 are going to have to be reported back to the C3 to count as its own lobbying expenses. If you don't want to do that, if you don't want to count the C4's lobbying expenses as your own with the C3, and as you know, C3s can engage in lobbying, not political campaign activity, but they can engage in lobbying, but within limits, cannot be more than insubstantial. And there are two sets of lobbying definitions for C3s, depending on whether you make what's called a 501H election. Again, that's an area I do a ton of work, but way more complicated than we can cover today. But essentially, if you make a grant that says you can use this for XYZ purposes, but you cannot use any portion of it for lobbying or political campaign activity, then you're not going to have to count that as lobbying. But it also applies, now the practical reality is a lot of C3s will not make grants to non-C3 entities. We have a lot of clients that are C3s that are grant making entities. Like the National Fish and Wildlife Foundation is a big client of ours that makes a ton of grants every year, but they're only going to grant to other C3s or sometimes governmental entities, but mainly other C3s. But technically under the tax code, if you're willing to, you can make grants to C4s, C6s, even for-profits, so long as it's a controlled grant that basically means you can only use it for these limited, XYZ purposes that are consistent with a 501c3's mission and purpose. And there's reporting back to the C3 as to how the grant was actually used. And while it's not a common practice, it's permissible under the tax code.
Okay, great, thank you.
And by the way, all of what I'm talking about is for public charities. So all C3s are subclassified into public charities and private foundations. Very different and more restrictive rules for private foundations. But what I'm talking about is for public charities, which I think would be most of the folks on the call.
Sure, yeah, I think so too. Okay, all right, Mike, I see your question. Jeff, the IRS is forgiving penalties for late filing of 2019 and 2020 for all entities except for 990 filers. Is an effort, do you know of an effort being made to have 990 filers included for late filing penalties related to Form 990?
No, I've not heard of anything like that. And look, It's different. I mean, I can understand the rationale for not having that, late filing exception for 990s, because with a 990, it's an information return. It's not a tax return. And I think the thinking was during, the heart of the pandemic, that a lot of people were going through a lot of income struggles, and, both individuals and for-profit corporations, and were having trouble paying their taxes, and therefore weren't necessarily filing on time. But with a 990, there's no taxes involved. If you have a 990T, of course, you are paying unrelated business income tax. And if you have any of the proxy tax for C6s. But other than that, it's just an information return. It can be filed electronically, whether you're working in person or remote. And so it's just not as much of a rationale for that. And I've heard no movement on or any push for anything like that. And also know that, in addition, you can get like this virtually automatic 6-month extension. There are penalties for late filing after that. And this comes into play with a lot of times with like smaller state and local chapters of nonprofits in the US, that if any tax exempt organization fails to file a Form 990 3 years in a row, it automatically loses its tax exempt status. And in addition, a lot of national tax exempt organizations have a group exemption that applies to their chapters or regions or components, whatever they might be called. And if you have a chapter that's subject to your group exemption and they fail to file the 990 3 years in a row, then they cannot get it back by just being added back into your group exemption. They have to either file their own version of the 1023 application, 1023 or 1023 EZ, or they'd have to form a brand new entity, get a new EIN, and then they could have that new entity added to the group exemption.
Great, thank you. I'm gonna jump back just for a second because they want to hear it from an attorney about donations and solicitation. Do unsolicited donations from members trigger the same state registration requirements? Unsolicited.
So first off, we're talking about C3s or say C6s or C4s. There's a big difference. One thing that came up last week in a conversation with a client that they were not aware of is that if a C6 or a C4 is soliciting donations or contributions from anyone, which happens sometimes, not often, but it does happen, there's actually an affirmative obligation for, say, the C6 to tell the would-be donors that they're soliciting that their contributions are not tax deductible as a charitable contribution. You can also tell them that they may be tax deductible as a business expense, say if you're a C6, but not as a charitable contribution. But this only applies if you're soliciting a donation that has donative intent. If you're just soliciting membership dues or sponsorships or trade show exhibit fees or advertising or you name it, that doesn't have donative intent. So that rule is not going to be triggered. But if it's a C3 and you are soliciting contributions, wait, what was the question, Carrie?
Well, they're clarifying now that this is for a C3. This is a donation for a C3, and it was unsolicited donation from a member doesn't trigger the same state registration requirements. So this is a C3.
Yeah, so we did, back when I was at Venable, we did some research on this, and there actually, so we did it for C3 membership associations, and the question was, if you're just soliciting your members for contributions, not for membership dues, but for contributions, is there an exception from registering under the state charitable solicitation registration laws? And for the most part, in virtually every state, the answer was no. There's no exception for that. Now, I think the question here was if the C6 is soliciting contributions from, say, its members for contributions to its related foundation, which is a C3. I believe that's what the question was. Does the C6 have to register? It's a very good question. And I believe the answer is yes, technically. Now, I think the practical reality is that very few would do that. Now, if the C3 itself is already registered, then I think that's going to pretty much obviate the issue. But if the C3 is not registered in any state and the C6 is the one doing the solicitation, if I recall the way that most of these statutes are written, they're not limited just to C3s. They have to do with, are you fundraising for a C3, which would be the case in that particular situation. Happy, whoever asked the question, feel free to follow up with me and happy to drill down a little bit deeper. But my initial instinct is that technically there would be an obligation to register.
That is complicated. Yeah, thank you. And then an additional question, how does that change the rules for a C3 that has been created to support the C6 with an online page that has the opportunity to donate to a particular cause that is charitable? Wondering about registering in all states with contributions.
Yeah, so that goes back. So what we're talking about is what we call a supporting organization. And like when we set up like a C6 or a C4 wants to have, a related foundation that helps to support it. The C3 can qualify. All C3s are either public charities or private foundations. To be a public charity, which is more favorable, you have to meet one of the three, technically four public support tests under sections 509A1, A2, or A3 of the Federal Tax Code, or the facts and circumstances test. 509A3 is the one that's designed for supporting organizations, and it's a really nice tool because it kind of provides a legal excuse through the tax code for the C6 to exercise more control over the C3, and the C3 itself doesn't have to meet the public support test. You look to the C6 to see if the C6 itself meets the public support test. That's just an aside. But as to that question, the question is really comes back to those Charleston principles. If the C3 is not actively and affirmatively soliciting residents of any of those 40 states, but it has a donate now button and it is accepting, kind of passively accepting contributions, unless you have persistent and consistent contributions from residents of a particular state, you're probably not going to have to register.
Great, thank you. All right, I'm going to take one more question on charitable solicitation. Is there an exemption for religious organizations from registration?
I don't know the answer to that. Frankly, we don't represent many religious organizations. I have an attorney out in California that I refer that work to, who's really good in that area. But I don't think I've ever looked, or my colleagues have never looked at the charitable solicitation registration laws to see if there's exemptions for religious organizations. I would not be surprised if there are, because there are a lot of exemptions, even in the federal tax code. Like churches don't have to file the 990 and synagogues and whatnot. But I don't know the answer to that offhand.
Yeah, we don't get a ton of churches and religious organizations attending either. So if anybody who's on the call has ideas about that, I'd be interested in hearing from you in the chat too. Thank you. All right, moving on. Is there a legal benefit from a general liability risk perspective of moving the endowment into a separate entity such as a historical trust?
So here's the thing, and we do a lot of work with subsidiaries, affiliates, and using other entities, and more so than ever before, regularly use what we call single member LLCs, limited liability companies, to kind of isolate liability risks in all different contexts. And with a single member LLC, like the nonprofit can be the sole member of a limited liability company, and then the LLC can be what's called disregarded for federal income tax purposes. So it is part and parcel of the nonprofit's tax exempt status for federal income tax purposes. It shares the exempt status. All of its income, expenses, assets, liabilities get rolled up into the tax exempt organization for 990 purposes and whatnot. But for liability purposes, it is a separate legal entity as long as you appropriately follow the right corporate formalities. And so when you're trying to isolate liability risks, so for instance, I have a 501c6 professional association that created a new accreditation program that was pretty risky, and they wanted to isolate the association's assets from those liability risks. So we formed a single member LLC to house that accreditation program. All the contracts and whatnot were entered into with the LLC. That helps to protect the nonprofit's assets. And in some cases, we have some clients where they're, if I could draw like an org chart, you'd see like main nonprofit at the top, and then you have a single member LLC beneath it. And then you have like branches down, state-specific LLCs for the operations in different states where they carry a lot of risk. And each one of those, think of it as like a liability shield, like a box that helps to isolate the liabilities within that LLC so they can't go up to the others. So that same principle, could be used to insulate, significant assets or reserves that you have if you wanted to do that. There'd have to be a bona fide business purpose for having the entity in order for that corporate veil to be respected. But certainly it's something to consider. And anytime you're carrying on activities that carry with them some significant liability risk and you have some good assets, you want to try to isolate those assets as much as you can.
Yep. Thank you. Just a couple minutes left. I'm gonna try to get through these last few questions. So let me scroll back up here. This was a little specific. How should plan administrators address SERP lump payments for executives that are being negatively impacted by a dramatic increase in IRS segment rates?
Yeah, unfortunately, that is one of the areas that we don't dabble in, employee benefits and retirement plans and deferred comp. I have an outsourced lawyer that we use for that, but it's far too specialized. And so unfortunately, I can't answer that question.
That's okay, because we'll have an employee benefit plan session during the symposium. So you guys will get that later. Okay, more and more cyber currency. I'm going to say cybersecurity. More and more cyber currency donations are coming in. Can you talk about the complications this can bring, especially on revenue recognition? Maybe more of an
I mean, that's really an auditor question. And I already spoke generally to that issue earlier.
Do you have a client which uses 501c agency's trust for unemployment tax program? I'm gonna get all these last.
I don't really understand the question.
This is your last chance, guys. We only have another minute or so. When and why would a resale tax exemption certificate apply to a 501c6?
Not usually. State sales tax, sales and use tax exemptions are all governed at the state and sometimes local level, and they vary wildly from state to state and city and county and whatnot. Generally speaking, most sales tax exemptions are limited to C3s, but usually there are other limitations, but the C3 status is a prerequisite in order to qualify. But I do remember in maybe a handful of city, states, or localities where a C6 could qualify for a sales tax exemption, whether it's resale or whatnot. And in some places, we see this in sales tax and especially in property tax exemption. Sometimes it's written into the code, into the state or local code. And sometimes I have seen some C6s kind of written into the actual statute as being exempt.
All right, for your last question, I have a softball. What is your favorite drink to serve from Quarantine Cocktails and why?
Yeah, so for those of you who don't know, I spent the early part of the pandemic, in addition to building the law firm, right here in my home, writing a book called Quarantine Cocktails. So I came up with about 75 different cocktails, some pretty creative stuff, and photographed them all and ended up publishing it in a hardcover book form. I get that question all of the time, and the honest answer is I don't have one. I don't have one favorite. I made them all, I photographed them all, and I drank them all, and they were all delicious. Some more than others. But for those of you who've seen the book, and by the way, there's a digital version. If Ashley, if you want to post it, quarantinecocktails.com. There's a free digital version. You can see it there, and if you page through it, you will see that there are quite a number of tequila and mezcal cocktails. So I would probably say the tequila and mezcal cocktails, because that maybe is my favorite spirit. I love bourbon, I love gin, I love other things too, but probably one of tequila or mezcal cocktails. And before we started this webinar today, Carrie asked me if I would come up with a kind of a signature cocktail to be served at the happy hour or the reception at your December 13th in-person event at the DC Convention Center, and I promised I will do that, and I will be there to help taste it.
Wonderful, thank you. And if you have any other questions, guys, that we missed, you will just have to bend Jeff's ear when you get to the reception on December 13th, because that's all the time that we have for today. I want to thank Jeff again for coming in here. I don't know anybody else who would do this. Just open yourself up to ask me anything for an hour, rapid fire questions for an attorney. It's always really valuable and really appreciated. So thank you, Jeff. Thanks everybody else for joining us today.